As an estate planning attorney, a big question I get when helping folks create their trust is, what do I do for a distribution? And that's kind of an awkward question because at the end of the day, I don't know your family, you know your family. But what they're really getting at is what sort of terms or conditions can I put on the distribution for my trust? And the answer for that is not an it depends, it's really a, well, what do you want to do? Because frankly, you can do almost anything with the distribution for your trust. There's a few parameters, a few guidelines, but at the end of the day, it is easier if folks just tell me what they want to do, and before I can go through and pick out, okay, you can do A, B, C, and D, but that last thing we can't do. So today, what I want to do is go through a few of the things that you cannot do for the distribution of your trust, and I want to give you some examples of some more complicated and fun distribution plans that folks have come up with. But as we get into it, thank you very much for watching. Please be sure to hit the like button, subscribe, and let's dive in. When it comes to what we cannot do in the distribution for our trust, there's one main rule that we do have to worry about, yet it's one that a lot of people don't understand. Frankly, it is kind of weird rule. It's the rule against perpetuities. And what it essentially is saying that all trusts need to end at some point in time. And it's a big, long, kind of complicated rule, but what you should just keep in mind at the end of the day is the way it works is that the trust has to end at some point, and that some point in time is typically 20 years after the death of the last named beneficiary within the trust. The rule is going to be slightly different the way it plays out in real life, but if you just kind of keep that parameter in mind, that essentially sets an end date for your trust. Decades after the death of the last named beneficiary, that could be many, many, many years down the line. Generations down the line, really, depending on how long you lived and how many generations of children that you had. So that's a long-term end goal for the trust. Aside from that kind of hardline rule, we do have some other more malleable or wishy-washy rules that we have to keep in mind. And these are rules that we don't necessarily have a specific probate code section to point to that gives us these parameters, but these are really rules that have kind of been handed down over time, primarily just through case law. And these are things that are contrary to public policy. So what does that mean, contrary to public policy? What is public policy? There are kind of general guidelines or rules that us as a society have generally kind of accepted in things that we want to have happen. So for an example, one of those is the creation essentially of a family, whether that be through marriage or just having children straight out. So when you're designing the distribution for your trust, you cannot condition one's distribution of not having a family. So what does that look like in practice? So for instance, if you're going to leave money to somebody, but put a condition on there to say you only get this $50,000 if you don't have kids, well, you can't do that. There's case law against this sort of thing. It's contrary to public policy. We do not, as a society, want to be discouraging people from having children. Same from a marriage standpoint. You can't condition someone's inheritance so long as they stay single. There's case law on that too. Contrary to public policy, we want folks to be starting families, getting married, having children, and everything that goes along with those. Another factor that comes into play for a distribution is, okay, maybe somebody is a contingent beneficiary. They only receive something if the person ahead of them in line has passed away. What that means, though, is you cannot take that person out in order to put yourself further in line. If that were to happen, the law is going to say, we're just going to skip over you and we're going to go to somebody else in the line of succession. So essentially, you cannot take out your predecessors in order to put yourself further up in the line of inheritance. As I said before, you can do a lot with your distribution. You can put a lot of different terms and conditions in there. You can condition someone's inheritance to where they only get it so long as they do go out and get an education, for example. However, you cannot condition their inheritance. They only get it if they do not get an education. That'd be contrary to public policy. We want people going to school. But if they do go to school, you're going to get an extra little bonus as a part of your inheritance. That's something that's totally fine to do. So today, I want to give some examples of some real distributions that we've designed for some of our clients. It'll get kind of the wheels turning in your mind as to what you want to do and showcase the examples of how complicated a distribution can be when we do want to set some parameters. In the vein of an education, we had a grandmother creating a trust and designing her distribution around giving an inheritance down directly to her grandchildren. She left a little bit for her kids, but at that point she wants to leave it mostly to the grandkids. Most of the grandkids, they're older. They're in their teens and early 20s. A lot of them are in line with going to school, and there's one grandchild in particular that grandma kind of favors. I mean, it's the one that takes her to the store, to the doctor's appointments. It's the one that actually is around to help take care of grandma. Now, grandma loves all her grandchildren, but this one is the one that actually is around to help her. So she wants to leave a little bit extra. But that grandchild, they're not irresponsible, but they could use a little bit more incentive to get their life sorted. So in this case, the distribution for everybody was conditioned on being age 25. So all beneficiaries, in order to receive their portion, they need to be at least 25 years old. If they weren't 25 on their 25th birthday, here you go, here's your inheritance. But for this one particular grandchild, the one that was taking care of grandma, she's going to get a little bit extra. But to incentivize her, to get her life sorted, grandma put an age 35 clause on there. So she only gets her inheritance at age 35. However, she can get it early if she goes out and gets an education. In this case, we put the requirement of either a 4-year degree at a university or some sort of vocational licensing. If she were to get either one of those and present those to the trustee of the trust has full rights to then take all the money out from the trust and give it to that beneficiary straight away. Plus, the trustee has the ability to use those funds in order to fund that education in the first place. So again, a real incentive to say your education is going to be paid for and whatever's left, you're going to get at the end of the day, even if you're not yet 35. So go out and get an education. In the same vein of keeping money until beneficiaries reach a certain age, our next example is a mom who is creating her trust, and in her trust, she is going to have all of her assets remain in trust following her passing until her children are age 65. Yes, a 6 and a 5. So everything stays in trust until they're essentially retired. So the intent in this case was mom was creating a retirement fund for the kids for the future, so they're not enriched with an inheritance now. Essentially, I'm going to encourage you to get your stuff in order, go get an education, get a job, get a career, actually build your life, and I will make your retirement easier. So you can't slack off while you're alive and in your working years, but I'm going to help you out at the end of the day. Now in that case, mom didn't totally leave her kids out to dry. That money is allowed to be used, again in this case, for education purposes and for medical emergencies. Also, mom's primary residence, that's going to go out to the kids. I think in that case, it was age 45. So they will get a little distribution at age 45. The money can be used in order to help them advance their education and their careers and also cover any unintended or unexpected medical expenses. But at the end of the day, the point is to create a nice little nest egg there, a nice retirement fund for her kids. Kind of springboarding from there, we have an instance of mom and dad who have 3 kids. They've got good kids. They are all getting out and getting their education. Most of them are in long-term careers by this point. But their middle child needs a little help. And not so much for himself, but with the person that he married. His wife likes to spend money, and he doesn't know how to budget. Now, they're not horribly destitute or anything like that, but mom and dad are worried about those two just burning through any money that they would receive and not keeping anything for a rainy day. So in this case, mom and dad decided to do a distribution outright to their oldest and their youngest children. But for that middle child, his share is going to stay in trust, in that case, until 60 years old. Again, a long time down in the future, but the point was to have those funds held in reserve in the trust for use in order to help him pay for things throughout life, education, medical bills, things like that, but it's not in his name, so he can't go through and spend it all right away. That was one of those cases where I was asked, can we condition it to say he gets his inheritance early if he ever gets divorced? Which then brings up that argument, contrary to public policy, that would be essentially encouraging him to get divorced and discourage marriage, which is something that generally as a society, we don't want to encourage people not to get married and everything. In that case, mom and dad were going to have a sit-down conversation with their oldest and youngest child to essentially say, hey, if your brother does end up getting divorced, go ahead and just empty out the trust and give him the money. We did have a condition in that trust built in that would allow the successor trustee to do a preliminary distribution or an outright distribution of the trust if they felt it was going to be in the best interest of the beneficiary. Ultimately, in that case, they decided to just do away with all those terms and conditions, probably after having a conversation with the oldest and the youngest kids. But that's an example of a distribution plan that we were going to be putting in place. Now, that takes us to a more complicated distribution plan. Mom and dad have 3 children, and they have 5 properties in total. 4 of them are rental properties. 2 of the rental properties have multiple units on site. So they're all of varying values and they all bring in different amounts of income. Yet, how do we make the distribution of those assets equal between the 3 kids? While taking into account the income of the rental income between the properties is very difficult to do, especially when we're trying to think in timelines of 10 to 15 to 20 years down the line. Now in this case, sure, mom and dad could just say equal among the kids and they'll figure it out, maybe somebody buys the other out. But they do want to go through and kind of specify who's going to get what property, because there is going to be a little bit of emotion tied into it as to who wants which property. So in order to jump ahead of any sort of fights on that front, mom and dad decided to allocate the properties between the different kids. The properties themselves all are worth different values, so we tried to roughly make it equal, but again, because we're thinking in timelines of decades, who knows what the value of those properties are going to be like 5 years from now, let alone 10 to 15 years from now when mom and dad actually start passing away. So in this case, we allocated 2 properties to one daughter, 2 properties to another daughter, and the last daughter got 1 property, but that was the big one. The big one, it had the most number of units on it. It had, well, beachfront property with it too. So that was the most valuable one. Now again, income on all these properties is very difficult to try to keep together, so we're mostly concerned with the values of the properties. But the values of the properties are going to fluctuate over time. So in this case, after allocating these properties to each beneficiary, the trustee is then going to need to make all of it equal at the end of the day, depending upon the value of the properties at the time. So the question is, how do we do that? In this case, we're going to first look to the money in the bank and try to use that to fill up portions as needed in order to try to equalize the distributions. Of course, it's probably not going to work out just with the money in the bank. So we also specifically empowered the successor trustee to encumber properties that have more equity to then use some of the money from that and allocate it to those beneficiaries with properties that have less equity. So essentially, the trustee, after allocating the properties to everybody, figuring out their values, and then distributing the money too in order to make things equal, if it's still going to be an unequal distribution, then we can lower the value of one person's portion in order to allocate some of that money elsewhere, so that at the end of the day, even though the properties themselves are not of equal value, the equity across all the properties, including any cash in the estate, will ultimately make things equal. Now, that is going to be a complicated distribution. There's probably going to be a lot of back and forth and figuring out what's the value of all these properties. But at the end of the day, mom and dad are trying to make things equal, knowing full well that daughters would probably fight over any particular property if mom and dad did not specify. And daughters don't necessarily want to go into business long term with each other and be landowners together. So this is the fairest way we can kind of come to terms and still give them some advice and direction as to what they're supposed to do. Now again, when it comes down to designing your distribution, you can be as straightforward, easy as you want, equal among the 4 kids, or you can be very complicated. A lot of the cases we just went over. At the end of the day, there's a few restrictions, but just think about what you want to do, then you tell me, and I'll tell you if it's something that you can't do. Most of the time, it's something you can do. It's just really about how am I going to get the wording down to get it done for you. But with that, I just wanted to have this as an example of what are some of the more complicated distribution plans that we can ultimately put in place, as well as give you an idea of the few parameters that we do have to adhere to when designing the distribution for your trust. So what did you think about those? Were any of those surprising? Do you have any questions on any of the distributions I talked about today, or want me to go over your distribution plan? Let me know down in the comments below. I'm attorney Andrew Bethel, and thank you very much for watching. I'll see you at our next meeting.